Great. Hi, good afternoon, everybody, and welcome to this seminar. My name is Karim, and in this seminar, we're going to be talking about a decision handed down by the Vice President of the Court of Protection last week. And like most Court of Protection decisions, some of them attract a lot of media attention, and this one in particular is highly contentious because it considers quite significant ethical and legal problems and provokes has provoked a lot of debate in the media. Just to be specific about it, this case decided that a care plan to facilitate C's contact with a sex worker could be implemented without the commission of an offence under the Sexual Offences Act 2003 on the basis that it could be read compatibly with the European Convention of Human Rights, in particular Article 8. And the court found that there was no need to make a declaration of incompatibility under the Human Rights Act. Just to give you a bit of a flavour of the type of commentary that's flying around in the ether of the internet, Julie Bindel of The Spectator negatively described this judgment in the following way. In the latest episode of You Can't Make It Up, a court has ruled that it is lawful for carers in particular circumstances to assist their clients for paying for sex. Conversely, Melanie Phillips in the Times yesterday wrote that this judgment was a very fine judgment and Britain has become a better place for it, observing that the decision was sensitive, compassionate, and captured the essence of true liberalism in extending tolerance towards an activity which, although it is legal, one may disapprove of. So the views are clearly polarized, and we're not here today to talk about the ethics or the politics of the decision, but we're here to talk about the practical and legal consequences of the judgment to those who are at the coalface, be it the statutory bodies or deputies. And I'm not really interested in talking about theoretical or academic points, but really how the judgment, or this landmark judgment, really affects us and our client base. So if I was a talk show host in the States, I would describe my panel as an A-list celebrity panel. And I'm sure they won't mind if I call them by their first names when I describe them. And they draw, I should say, on their extensive experience in both welfare and property and affairs. So from King's Chamber's Court of Protection team, we have Faye and Aisling. And it should be noted that Aisling was the junior on the case instructed by the CCG. Leah is an associate at the healthcare department at Hill Dix and represented the relevant CCG in this case. Holly is head of department and partner of a private client at Morrison Solicitors and actually provided a witness statement in the case asked by the judge as her role as the director of the Professional Deputies Forum. Tom is a solicitor at Price Slater Gorn and specialises in Court of Protection cases. And finally, Chris is a partner at Gillingham Solicitors, specialising in private client and acts as a professional deputy appointed by the Court of Protection. There is a question and answer facility, and we'll be taking questions at the end of our session in about 45 minutes. So please use the Q&A function at the bottom right-hand side. Now, as lawyers, we all say that the outcome of a case is all dependent on the facts. Now, that phrase is no more important than in this case. So, Aisling, do you want to tell us about the facts of this case?
Yeah, hi everybody. So this case concerned C, a 27-year-old young man who'd been diagnosed with XXY syndrome and autism spectrum disorder. And as a result of both of those things and some of the associated difficulties, he displayed quite challenging behaviour throughout his childhood and ended up as an adult needing quite significant assistance with his daily living. That culminated in 2014, him being detained under the Mental Health Act for 3 years. Essentially, that was because of a deterioration in his mental health, but also significantly because he was articulating threats of a sexual nature, although the judgment's quite careful to point out that he never acted on those threats. He received a lot of medication, a lot of therapies, and was eventually discharged to where he is now, a supported living placement, and he's deprived of his liberty there. 3 years ago now, in 2018, C told his Care Act advocate and eventually litigation friend that he wanted to engage the services of a sex worker. He essentially decided that he wouldn't have very good prospects of being able to find a girlfriend and to engage in sex in sort of more organic ways. So that was the solution he'd come up with. And perhaps the key thing, the key fact in this case is that C had been assessed as having capacity to engage in sexual relations and to have contact with a sex worker.
Great, thanks, Ashley. So what I was going to do is just give you a brief outline of the legal decision and the legal issues that came before the court. And I think in terms of the facts, the headline features, as Ashley just said, was that C was described as having the ability to make decisions to engage in sexual relations and to decide to have contact with the sex worker, but he lacked capacity to make the practical arrangements involved in identifying a suitable and safe sex worker, and was unable to negotiate the financial transaction. And so very specific decisions were considered by the court. And what was proposed was that C would be assisted in these arrangements by carers who, as the quote, and I quote from the judgment, paragraph 91, who the judge said were sympathetic and content to help him. So there were essentially three issues which were before the court. The first was whether the care plan to facilitate C's contact with the sex worker would commission an offence under the Sexual Offences Act 2003, and if not, whether the Sexual Offences Act could be read compatibly with the European Convention of Human Rights, and whether the court should make a declaration of incompatibility. And finally, if a care plan facilitating such contact was lawful, and whether it be in C's best interests. And it's worth noting that the final part has yet to be decided. So what does this Sexual Offences Act say? Well, in particular, I'm just giving you a bit of a brief summary. Section 39 says that a person A commits an offence if A, he intentionally causes or incites person B to engage in an activity, and the activity is sexual. B has a mental disorder. A knows or could reasonably be expected to know that B has a mental disorder, and A is involved in B's care in a way that falls within Section 42. Now, all of that might sound gibberish, and I think for a lot of us it did for a while. So I kind of urge you to have a look at the specifics of Section 39. But what is important is what Section 42 says, because that defines a person involved in B's care. And what that says at Section 42(2)(a) is that the subsection applies if B is accommodated and cared for in a care home, community home, voluntary home, children's home, or premises in Wales in which a secure accommodation is provided. And then subsection 4 says that this subsection applies if A is whether or not in the course of employment a provider of care, assistance, or services to B in connection with B's mental disorder, and B as such has had or is likely to have regular face-to-face contact with B. Again, urge you to look at the statutory provisions in some detail. What the judge essentially said was the gravity of these offences is illustrated by the fact that it carries on conviction indictment of a maximum sentence of 10 years. So if someone's involved in inciting, for instance, and if you are convicted, then you're subject to go on the sexual offences register for a period of 5 years. So it's quite significant. It's worth just noting that there has been previous case law on it. In 2019, the case of Lincolnshire CC and AB, Keenan J decided and said in relation to Section 39 that I note that a care worker who causes or incites sexual activity by an individual for payment with another person commits a criminal offence. So that was his observation pursuant to Section 39 and 42 and 53A of the Act. Despite all of that, the Vice President took a different view, and the way he constructed his conclusion was to look at it this way. He said that, first of all, there could be no dispute that C had a mental disorder, which is quite uncontentious, and that C was known to a carer, and what was contemplated was sexual activity. That's the easy part. The central question, he said, was whether the carer is inciting or causing C to engage in activity which is sexual. And he said, obviously, that section 42 is intrinsically linked to that definition. So he asked the question whether it would incite, and his answer was that the Sexual Offences Act in paragraph 44 was directed, and that's a reference to his judgment, directed towards the protection of those who are sexually vulnerable in relationships which may easily become exploitive and in which inequality may corrode meaningful consent. The clear intention of Parliament, and I emphasize this, is revealed when the statute is considered and its entirety and the wording given its literal meaning. So what he meant by that was what he expands further at paragraph 89, where he said the central philosophy of the Sexual Offences Act was to protect those relationships predicated on trust, where the relationship itself evaluates vulnerability. So in short, what he decided was a literal interpretation of section 39 meant that carers would not be criminalized because their motivations weren't covered by the mischief of section 39. The other point of worth recognizing is that he did say that C's Article 8 right was engaged, so his intention or ability to be involved in sex relations was something that engaged his Article 8 private life. So the court decided, in short, at paragraph 95, that applying a literal meaning of the statutory interpretation of section 39 and 42 meant that it could be read compatibly with C's Article 8 right, and so there was no need for a declaration of incompatibility. Now, that was a bit of a tour de force of what the court actually analysed in a very detailed judgment, but I urge you to read the relevant statutory provisions and his reasoning. But in terms of the actual appeal, because unlike a lot of other cases, the judge granted appeal, permission to appeal at the hearing. So, Leah, what was the basis, if I can ask you, of that appeal, and did we get any insights in terms of the judge's view and the views of the Secretary of State who asked for permission to appeal?
Yes, thanks, Sam. So yeah, the Secretary of State applied for permission to appeal, and this was on the basis that Hayden J fell into error in his interpretation of the words intentionally causes or incites within section 39 by failing to give the words their natural meaning. The Secretary of State's position was that had Hayden J given the words their natural meaning, he would have concluded that even where P has capacity to consent to sexual relations and have contact with a sex worker, by assisting him to do so, a carer would commit an offence under section 39. It was also contended by the Secretary of State that Hayden J's interpretation would in effect give the courts authoritative approval of prostitution, which is contended by the Secretary of State to be contrary to public policy. The grounds for appeal relied on by the Secretary of State focused on the criteria in the civil procedure rules at 52.61b, that there is a compelling reason for the appeal to be heard. They submitted that the judgment addresses extremely sensitive, far-reaching issues which have direct impact not merely on C in this case, but across a range of people with mental health disorders and in a variety of situations. They further argued that the subject matter of the judgment falls within a small and discrete category of cases which have such a far-reaching social implications that they should be authoritatively examined by an appeal court. C, by his litigation friend, argued that a decision had not been made involving C or in some way about C, and therefore there was nothing for the Court of Appeal to bite on. In the concluding paragraphs of the judgment, Hayden J asserts that his interpretation of section 39 is directly relevant to C, as well as to others, in that it affords him a gateway opportunity for a care plan to be prepared and subsequently considered, which may or may not ultimately be assessed as being in his best interests. And he goes on to say that the statutory interpretation of section 39 is not academic, but is an essential preliminary to a decision for C in an immensely important sphere of his life, and that therefore the judge was entirely satisfied that there was a decision to be appealed. The judge also went on to comment briefly about the Lincolnshire County Council and AB case, Sam, that you mentioned from 2019. and that there is room for argument that there now might be two contradictory views on the scope and reach of Section 39. But ultimately, the judge granted permission for the Secretary of State to appeal on grounds that the tension between the general policy considerations in relation to sexual workers that were identified on behalf of the Secretary of State and his own interpretation of the wording of Section 39 falls within the small and discrete category of cases contemplated by Rule 52.6 1b, and that there is a compelling reason for the appeal to be heard.
Excellent, thank you. And do we know, obviously we can't say too much, but do we know when the hearing is going to be listed?
I understand before the end of May.
Right, so it's going to be quite a quick decision from the Court of Appeal.
It is, yes.
Excellent. Well, Leah, if I could stay with you, because obviously in your role as Associate at Hill Dickinson, you represent quite a few statutory bodies across the country. I focused in the judgment on particular Section 39 and 42, and that's what the judge did. But are those the only relevant provisions, or are there wider considerations that statutory bodies may have when reading this judgment?
If only so. Certainly in C's case, there was consideration of Section 53A, which makes it an offence to pay for the sexual services of a prostitute or a sex worker, where but only where she or he is subjected to force, threats, coercion or deception. And Section 33A2B provides that it is irrelevant whether the customer is or ought to be aware that the third party is engaged in exploitative conduct of the prostitute or sex worker. So in the judgment, Hayden comments that Section 53A2B creates an offence intended to protect exploited sex workers by criminalising their clients. Any customer who arranges to pay for sexual activity with a sex worker might technically commit this offence, whatever their state of knowledge or belief, if, but only if, it subsequently transpired that the sex worker was exploited in the terms prescribed by the section. So the offence would potentially capture even the individual who might have taken care to ensure that sex worker was not exploited. Hayden was able to navigate this by evidence submitted by Professor Detan, who is the chair of an organisation called the Outsiders Trust. The Outsiders Trust is a social charity for people with disabilities, and it incorporates what's called TLC Trust, which focuses on education and support for the provision of sexual and intimate services. All these sex workers who have profiles on the TLC website are said to be vetted and must undergo a screening process in which they must provide evidence on their real identity and that they've had previous experience in providing sexual services either through their own website or an existing adult services platform. And they're also asked about their personal and professional experiences of disability and how that might make them suitable for such work. So the judge, having considered the evidence of Professor Detan, it was his views that Section 53A has little, if any, relevance to what is being contemplated for C. And he said that the focus must be on the protection of the individual, on the individual's autonomy and accompanying vigilance to ensure that vulnerable are not exploited or placed at risk of harm. And he did recognise that vulnerability may not be confined to the protected party in the proceedings. So it therefore follows that Section 53A should be considered by statutory bodies, particularly when selecting a potential adult service provider. Section 39 and Section 42 are, like Hayden J suggests in the permission to appeal judgment, the gateway for a care plan to be prepared and subsequently considered in terms of best interests. So other ancillary activities to consider, certainly when considering care plans and how things might work in practice, might include offences relating to procuring or keeping a brothel, particularly if the suggestion is that the sex worker visits P rather than the other way around, and if P does not live alone, and if flatmates or housemates start then expressing wishes and feelings in respect of them too accessing a sex worker. So does that then open up the care provider or landlord, or even P as a tenant of the property, to potential offences of keeping or procuring a brothel under the 1956 Sexual Offences Act? So I think the difficulty here is that there's no statutory definition of a brothel, and it's an offence for a person to keep or to manage or act or assist in the management of a brothel to which people resort for practices involving prostitution, whether or not for other practices. Case law on brothels specifically states it's not illegal to sell sex at a brothel, provided the sex worker is not involved in the management or control of the brothel. However, the premises only become a brothel when more than one woman uses premises for the purpose of prostitution, either simultaneously or at one time. So that's where P, if P lives with more than one person, and if they are all sort of wanting to have access to a sex worker, that's where these difficulties may arise. So it's particularly important that really careful analysis is given, and particular legal advice should be sought if there is any doubt.
Yeah, and so in terms of the commissioning of the package of care, and obviously that court hasn't decided that, and it probably won't do for the next couple of months whilst the appellate courts decide the appeal. But isn't it an almost impossible task then for, at the moment, a local authority or a CCG, for instance, to even think about commissioning a care plan such as this? And what kind of considerations should they be giving to it?
I think so. I think at the moment, obviously, it's pending an appeal, but whilst we're sort of waiting for that decision to come about, I think it's important to note here that the judgment we have centres on C, who's been assessed as having capacity both to engage in sexual relations and to decide to have contact with a sex worker. But C's been assessed, he lacks capacity to make the practical arrangements involved in identifying a suitable and safe sex worker, and is also unable to negotiate the financial transaction around that. So firstly, if a local authority or a CCG or statutory body, if they're sort of within this realm in terms of considering matters, I think firstly you'd want to arrange capacity assessments to cover the range of issues that might be brought into consideration. So you'd be looking at a capacity assessment to look at sexual relations, contact with a sex worker, capacity around financial affairs, internet and social media, and their care and treatment. There has to obviously be some regard in terms of how a care plan may work and what this is going to involve, as this will directly, affect. It will direct where further advice may be needed. So hypothetically speaking, when I was mentioning brothels earlier, is P able to leave the property, or would it be expected that the sex worker would come to P? I think obviously the issue that we've got is the judgment which centres on section 39 and 42, which, like I say, is the gateway to then start considering these care plan issues. That is obviously up in the air at present whilst the appeal process takes place. But these are certainly considerations that statutory bodies should be having. I'd also be saying, obtain legal advice, particularly for the statutory body or bodies involved, and also inviting the care provider and the care staff to seek independent legal advice, as this directly affects them. It's obviously imperative that any care plan that's put in place for P is lawful, so as not to place any carers or P liable to criminal prosecution. And this then obviously leads on to whether the care provider or care staff would then be willing to implement the care plan, as this inevitably determines the available options in terms of P's best interests. So as it stands, statutory bodies are going to need that further direction and assurance, which may or may not be forthcoming from the Court of Appeal. And it has to be said that whilst the current judgment provides that on its interpretation, the Sexual Offences Act wording, a care plan to facilitate C's contact with sex workers could be implemented without the commission of offence. The court can't grant that immunity from criminal prosecution. Yeah,
super. Thank you, Leah. I mean, Aisling, if I can just come back to you on 3 points in relation to what Leah was saying. The first is about capacity assessments and how capacity assessments, if you want to fit into this judgment, have to be very specific. So can you just talk to us a bit about that, a kind of an example of how, in this case, it was a very specific decision? The second thing is about the actual option. So was the commissioning a potential option in this case? Was there a provider available? And the third thing is about the DPP and whether there is any guidance out there in terms of what, when and how they would prosecute potential cases under the Sexual Offences Act.
Well, I'll go in reverse order.
Sure.
On the DPP point, the only real mention of it in the judgment is at paragraph 64, where Mr. Justice Hayden just says it might be possible to seek clarification of the criteria that the DPP would take into account when deciding whether or not to prosecute. But then, of course, he follows that up with the point that Leah has just made, which is that a grant of immunity from prosecution isn't on the cards. That isn't within the gift of the DPP. So at the moment, the court, I think, readily accepts that there isn't DPP guidance out there. Perhaps if there had been, we wouldn't have needed to bring this issue up to the Vice President of the Court of Protection. But certainly it would be helpful, I think, to have some input. On the option point, in this case, it was an available option, or when we went into the hearing, it was an available option. Because the care provider knew that we were going through legal proceedings to try and work out whether the care plan was going to be lawful or not. And they had said provisionally that they would be happy to consider implementing it. Obviously, that's somewhat more up in the air now than it was when we thought we were going to get a more final decision than we've ended up with. But in principle, yes, it's going to be an available option with this care provider, which was really important as a consideration because, of course, nobody wants to destabilise a care package that's working really well for P just to ensure that they could be facilitated to access sex workers if there's then not going to be a care package that meets their other needs. So that was certainly really important in this case, and I imagine it would be in others going forward. The final point then was about capacity assessments. This judgment, I think, really makes clear that there is a domain now of capacity to decide about contact with sex workers, and that requires its own specialist capacity assessment. So much as the engaging in sexual relations capacity assessment needs to be done and needs to remain issue rather than person specific, there is going to need to be a separate assessment of P's capacity in relation specifically to sex workers. And although it might seem artificial because one imagines that the reason that assessment is coming up is not because somebody plans to go and have dinner with a sex worker, this judgment clarifies that that is something that would need to be addressed before this sort of care plan could even be entertained.
Yeah. Thank you. So we've been speaking about statutory bodies and how it affects statutory bodies, this judgment on a potential care plan. But in fact, the implications are greater to some extent to deputies and property and affairs deputies, and especially the interplay of Section 42. So Faye, can I ask you to do a sub-panel with our panellists on the property and affairs side to discuss the implications?
Yes, thanks very much. Well, as you all know, the topic for this seminar is it lawful for the state to facilitate access to care workers? And of course, property and affairs deputies aren't an emanation of the state, but it's clear from the judgment and also the matters that we'll discuss in a moment that it's clearly of huge relevance and significance to property and affairs deputies. And for those of you who've actually read the judgment, you'll see at paragraphs 11 and 13, references to extracts of Holly's witness statement that she provided in the proceedings, which followed her consultation through the Professional Deputies Forum. And just reading that, you can see that it's clearly of significant concern to deputies. So I suppose I'm going to start with Holly first, given that we've been talking about her witness statement. Holly, you might forgive some people for thinking, well, why are deputies concerned about this? Because ultimately, and really it's a health and welfare decision, isn't it? But as we know, there are some aspects of P's life where there is that very blurred line between health and welfare and property and affairs. So prior to this particular decision, can you help us with, for a typical deputy, what would be their role, if any, in assisting and arranging P's access to sex workers or sexual services?
Yeah, thank you. I mean, I think the starting point is just to reiterate what Sam said at the beginning, and that is that there's already been a capacity assessment to ascertain that P has capacity to engage in sexual relations. And I think some of the media coverage has forgotten that. So that is a really important point to make, and that deputies aren't seeking to access or facilitate sexual services for someone who lacks capacity to do that for themselves, where the challenge is actually accessing those services, the practicalities of that. And that might be because the person's capacity to decide about how much money to spend, or to make the practical arrangements for getting to wherever it is they're going to meet the person. Or it might be that they just physically have an impairment that impacts on that ability. As you said, paragraph 11 of the judgment sets out a number of examples of where professional deputies are supporting clients to access sexual services. Now, the role, as you say, it's really difficult. There's a fine line to tread between the role of a property and financial affairs deputy and a health and welfare decision, which they would not have the authority to make decisions about, generally speaking. So in many ways, it's actually just implementing a decision that's already been made. So whether that's a mix of P having capacity to make that decision and or a best interest decision in terms of perhaps the practicalities of it, it's almost that the property and financial affairs deputy is just the person handing over the money or making those practical arrangements that involve spending money. You'll see from paragraph 11 that it's how deputies are supporting those clients is being done in a variety of ways, and that will inevitably depend on the ability of P to make arrangements for themselves. And one of the questions so I'm going on a bit of a tangent here, but one of the questions that arose, and it's set out really in paragraph 11, is whether a professional deputy or a deputy of any sort actually is caught by section 42, and is there a line with that? So, for example, if as a property and financial affairs deputy you say to P, here, have however much you need, I don't know, 100, 200 pounds, and you know that those funds are going to be used to access sex services, does that then bring you within section 42?
Yeah. I mean, I suppose when you look at section 42, my interpretation of where a deputy could fall into it is possibly subsection 4, which, and it says this subsection applies if A is whether or not in the course of employment a provider of care, assistance or services to B in connection with B's mental disorder. Well, if you have a broad interpretation of that, your involvement is in relation to their impairment, and you are providing a service. And then it goes on to say, and as such, so because of that assistance, has had or is like to have regular face-to-face contact with P. So it seems to me that you might say it's capable of encompassing a property and affairs deputy, but I suppose might be troubling to the three of you.
Yeah, and where it's also difficult is if the decision's already been made by someone, it's a best interest decision, or P has capacity, and you're just being told to hand over the money. What's your role in saying, well, I'm not going to do it because I might be caught by this, or I don't agree with it, or whatever? So it's not necessarily that the property and financial affairs deputy is the one making the decision. But
I think that's an important point actually to raise, because it raises a serious professional issue for the three of you as solicitors as well, doesn't it? Because there is a determination by others that have been made about a health and welfare best interest decision. As property and affairs deputy, arguably it's your responsibility to achieve the financial side of that. But if that's potentially going to expose you to committing an offence, is that something that the three of you would be prepared to take on that risk? And I suppose Tom, I can see he's shaking his head. What do you think about that?
It's a really tricky one, isn't it, Faye? And I think that this is where the point we're at with this judgment, that there's probably more uncertainty now than there was before, not just because of the pending appeal, but because of the number of questions that remain unanswered whilst we haven't yet dealt with the issues around the care support plan. And I think that the deputy falls into that a little bit. But from my previous experiences with cases that are similar to these facts, with a protected party where you've got a deputy but they've got capacity, or they've been deemed to have capacity to make these type of decisions, I think the deputy's involvement, from my experience, has been more at arm's length, similar to the points made in Holly's statement, where I think it's been that the funds have been provided under the guise of personal allowance, activity expenditure, rather than something that we've got so much direct control over. And I think that's also important for the sort of wider duties of the deputy, in terms of ensuring that the role isn't too restrictive, that there is a level of autonomy, particularly where there's issues that where the person concerned has got capacity to make those decisions. And so I think it's a really difficult one, and hopefully the sort of appeal and subsequent judgment looking at the care planning aspect of it will give us further guidance to help us with these difficult decisions that will always turn on their own facts, I suppose.
Yeah, I mean, I suppose and I think it's right about the arm's length transaction. I mean, essentially, the three of you are, as with many decisions on behalf of P in this setting, are the purse strings, aren't you? And so, but by virtue of doing that, it potentially exposes you to this particular risk. And I suppose that then brings me quite conveniently to the section 53A, which I have to say, my view about the judgment is it probably glosses over this, really. And I think the starting point is that there is, you can see from Holly's extracts in the judgment that there are a wide range of concerns, and there was a calling out for those to be addressed as best as they could be. And I think, to me, 53A is probably one that may well be forefront of most of your minds, because for those of you who haven't seen it, I'll try and read out as quickly as I can. It's paying for sexual services of a prostitute subjected to force. So a person commits an offence if they makes or promises payment for sexual services of a prostitute. A third person has engaged in exploitative conduct of a kind likely to induce or encourage B to provide the sexual services, and C engaged in that conduct for or in the expectation of gain for C or another person. So it's what the kind of arrangements that you might have where you have a street sex worker with, what's traditionally been called a pimp. And now, so if you as a deputy are applying that payment unwittingly and unknowingly of that background, then I suppose, again, that presents a risk that the three of you may well not be prepared to take on, certainly in a professional capacity. Chris, what are your thoughts about that?
Yeah, I mean, just building on what everybody said, one of the issues that we was considering earlier that came up is obviously most professional deputies are also solicitors, and so you can find yourself in a position where, as you know well from the SRA rules, that all solicitors have to conduct themselves in such a way where they uphold the public trust and confidence in the legal profession. And so you can imagine what the kind of fallout would be if, for instance, you have a difficult situation where P wants to engage with sexual workers. At the same time, he may or may not want his family members to know whether he's doing such a thing. And so you're slightly torn in the sense that you have a duty of confidentiality to P. And at the same time, you do have a duty to consult family members for material decisions. I mean, if, for instance, you can imagine if you didn't tell the family, they later subsequently found out what was going on, they would then potentially refer the professional panel deputy to the SRA, and we would find ourselves not just the criminal proceedings under the Section 53, but also professionally being investigated. We're in a bit of between a rock and a hard place.
Yeah, I think it puts you in a particularly invidious position, really, because as I'm sure you've all experienced at some point during your careers as deputies, is that sometimes the balance between an effective relationship with P and their family can be broken by something so minor in the grand scheme of things. And then it can lead to this change in the relationship that means that you can't properly act as that deputy anymore because there's been an irretrievable breakdown. And it's certainly not in P's best interests, and I'm firmly of the view of this, that there are repeated changes of deputies. And so I'm always encouraging deputies to involve families as much as possible within the remit of confidentiality, and obviously depending on how impaired P is. Because I firmly believe that leads to a happier working relationship. And if you get the family on board, then that helps most relationships continue. But quite rightly here, we also know that on the other side of the coin, you can sometimes get family members that get very frustrated by decisions that are made. And sometimes they don't always act rationally because things don't turn out the way they want it to. And as a solicitor and as any legal representative, you never want to be on the wrong end of your professional regulator, especially when you've actually really done nothing wrong. You're only trying to assist P in those circumstances. So I think it really does place solicitors and deputies in a particular invidious position. But I think for me, with Section 53A, I personally don't draw a great deal of confidence from the extent to which it's dealt with in the judgment. Because as I think Aislinn said, Hayden said that, well, here it doesn't matter because the services are going to be procured from this particular charity. So there's going to be no issue of effectively exploitation and street sex workers. But the thing is, as a deputy, if you're not the one who's involved in actually arranging and commissioning that, then how will you have the confidence to know that one of these individuals isn't subject to exploitation?
Hey, can I just come in on a couple of points? One is just picking up exactly what you're saying, and it's in the judgment. Is that there was concern expressed from one deputy that P was accessing services which we may consider to not be appropriate, although the way that he was accessing them, and it's brought up with C as well about using social media and the additional risks that are brought about as a result of that. So there is a risk that by deputies not supporting, I suppose, safe arrangements, supported arrangements, that actually you could push P to a situation that is far worse or potentially worse for them. So there's just the first point. And the second point, coming back to something I was mentioning earlier, is that if P has capacity to manage sums of money, it may be fairly substantial sums, or it might be smaller sums, but they're able to save. You can't necessarily restrict what they are using those funds on. And it may be this, it may be buying drugs, it may be buying alcohol, but you can't, as a deputy, say, well, I know that you are going to be, or I have a feeling, or belief that you're going to use these funds for these purposes, when the person has got capacity to manage those sums. So you have to, you have to allow them to have those sums of money, and if they're then using it for things that they shouldn't be, or are illegal, or would then bring you into Section 53 or 42 or whatever it is, that again inadvertently putting us in a position that's very difficult to
absolutely
explain.
And I totally agree. I think Hayden's absolutely right that this what we're talking about is not the mischief of the act, is it, that it's trying to deal with? And for me, it's a question of actually, even though it may be capable of an offence under Section 53, under Section 39, it's really a question of whether then the CPS would prosecute, which the reality is they wouldn't, because that's not the mischief that the Act is aimed at. And Peter Edwards actually raised an interesting question. We had a short discussion about this yesterday, because he said, surely the fundamental problem is that the Act is so out of date and government is unlikely to have the courage to address this. I think that's right. When we were discussing things yesterday, I said the reality is it's calling out for an amendment to the Act, isn't it, to deal with this? And my own view, and I'm not a criminal practitioner and never have been, but my property and affairs practice and my probate practice brings me into contact with it, because I very often have to deal, sadly, with misappropriated funds. And I'm particularly interested in, actively speaking with some deputies about potentially bringing private prosecutions of deputies and attorneys, because some forces, and CPS are just not willing to prosecute, because the age-old answer is, well, the person lacks capacity, so they can't give evidence, so we can't prosecute. But my view is, well, if they lack capacity, then they can't consent to the transactions, and it's all documented, or should be documented, in the bank statements. And I think this is another example of how actually the criminal law is quite outdated, and it's not moved with the times, whereas the 2005 Act is actually quite progressive, really, when you look at the law in other jurisdictions. And so you never know, Peter, it may well be that when this does land with the Court of Appeal, that it does start to get some people in the right departments twitching and maybe thinking about how vulnerable people can be enabled to access things that will undoubtedly improve their quality of life. And there's another question asked by Elizabeth Young, where she asks about if P's personal allowance is spent by them in accessing paid for sexual services, what's the OPG likely to approach the OPG like to take? And I suppose that's a question actually for you three. So I don't know if Tom or Chris, you know the answer to this, is have you had any feedback from the OPG or had any questions or challenges to these fees that turn up in the accounts?
Faye, I've not had any questions on this point from the OPG, but I've come across some situations where we've acted for lay deputies, I think more where the OPG have investigated some of the sort of finding details of particular types of expenditure. But generally speaking, I think that when it comes to things like personal allowance and activity expenditure, and you've got a professional deputy, surely it's got to fit within that professional deputy's discretion, and then the expenditure falls to the protected party to sort of have some autonomy over that. I don't think it would be right for a professional deputy to be stepping in and sort of scrutinising that expenditure too much. I mean, there's obviously, if you look at the OPG professional guidance, you could probably find remit there to go into someone's property and sort of try and account for every bean, every grain of rice in the house if you felt you have cause. But what would that achieve, and what would the impact be on the protected party? So I think it would just be really overreaching if we were to start to engage in that sort of process.
Yeah, it'd be too paternalistic, wouldn't it? Chris, have you ever encountered any sort of pushback from the OPG or any comments from them on this particular issue?
I haven't. One slightly different approach that we would normally take, because they do, obviously you submit those OPG reports every year and they'll come back with various questions, because that's their job to kind of spot check things and all the rest of it. One of the approaches that we take as a firm, I suppose, is that if there is something particularly contentious, something that you're particularly worried about, that it could maybe result in a court application at a later stage, I find it's much better off that you write to the OPG in advance. So if you're going to make these payments, if there is a care plan in place, if there is health and welfare proceedings, then I would take the approach that you write to the OPG and let them know exactly what's going on, and let them know that you will be making these payments. And then at least you've given them notice, and if they want to engage in that process and be involved in that process, then obviously they can do so.
Yeah, I think that can be said about anything really in affairs, can't it? I always say the sort of fallback position, if you're unsure about things, because there sadly is uncertainty about a lot of things, I think, following re-ACC and where the line falls on certain aspects of the authority. So if you are ever unsure, I always think the best practice is to sort of front load things and find out matters. One thing I wanted to ask the three of you actually is, I know that, especially Tom, because I work with Tom quite frequently, is that with large brain injury awards, where P will have a 24-hour care team and will have a large privately funded care package. And so as deputy, you are acting as an employer of that care team. How confident or not confident does this judgment make you about your role as an employer and your care staff potentially facilitating P's access? Over to you guys.
I don't mind taking this, Faye, just to say that this is where it probably causes me the most anxiety. As a court protection practitioner, I'm not an employment lawyer, although, as you say, we're engaged in directly employing support and care teams. I've not been in a position where we've had to raise or flag these issues, and I suppose this is where we still don't have the guidance on sort of the particularities of the care plan and what might be appropriate. I suppose in cases I've been involved with before where there have been sex workers and it's been funded through personal allowance payments, the support teams in those cases, or the care teams, were very much not involved. They were in the background. There was nothing particular that they were doing to facilitate arrangements. But it does make me feel very uneasy that we could effectively be employing someone and asking them to commit a criminal offence.
Well, yeah, I mean, imagine if you did that and then one of the carers were prosecuted, then it raises all sorts of problems for you as an employer, doesn't it? I suppose.
Yeah.
Sorry, Sam.
No, I'm just wondering whether this comes back to Leah's point, doesn't it? I suppose about asking the actual care agency or the care workers to get their own independent legal advice. I mean, one thing that just occurred to me was in the judgment, Holly, in the witness statement, insofar as that you can talk about it, paragraph 11, the judgment said that one part of the findings was that our members have experience of their clients seeking sexual services. I mean, obviously there's a limit of how much you can tell us, but is it quite extensive that deputies are involved? And I suppose it's a question to all of you in the commissioning, be it directly or otherwise, of individuals accessing sex workers.
I don't think it is that widespread, and I think it's limited, particularly as the report says, to sort of generalising, but men in their 20s. Either with a brain injury or with some sort of impairment, so like C. And I think it's at that age when your hormones are raging where it's more relevant. And I would suspect that if you looked at the breakdown of deputyship work, it's mostly going to be older clients who perhaps don't have the hormones. They may have an interest in accessing sexual services, but it's probably less relevant and less common than it is with younger clients. So I think it's not such a widespread issue, but it is an issue, and it only takes one, doesn't it, to appear plastered in the social media and the front page of the papers up for the SRA and everything else. So it is an issue.
Yeah, I mean, just the other thing that occurred to me when you were all discussing Section 53, I mean, quite unusually, the judge asked for specific advices from two silks, which are outlined in the judgment, but then quite readily went on to say that it carries no weight in his determination and referred to some decisions which established that authority. But he did refer to, didn't he, Aisling, to some CPS guidance, which Faye was talking about earlier in respect of Section 53.
There is some CPS guidance that helps with this. Obviously, it doesn't really help with the Section 3942 intersection that's been at the crux of these proceedings. The charging practice can be found at paragraph 26 of the judgment as a quote from Nina Graham QC's advice, and also on the CPS website. I'm not sure that it really makes anything very much clearer as far as Section 53A is concerned, because on the one hand, it makes it sound like quite an extreme offence. So we're thinking about off-street prostitution, police apprehending somebody who's paid for sexual services with a person involved in street prostitution, and then police brothel raids. There's an example given of offences not being limited to particular types of premises. So I think that gives the impression that it's quite extreme. But then on the other hand, it really tempers it right back down and says, well, it could apply to premises that have a legitimate business, for example, a nightclub and an online internet-based service. Again, there's the curious comment that in considering this offence, the previous history of the buyer may be a relevant consideration when applying the public interest test in the code. I think it's almost impossible to know how that would apply to somebody in C's scenario. What relevance would his history be to the prosecution? What relevance would the history of any care workers or any deputies or any CCGs or local authorities? It's very difficult to apply this to facts like ours, I suspect, because those facts weren't envisaged by either the CPS or the Parliament that enacted the Sexual Offences Act in the first place.
Great, thank you. Well, listen, I mean, individually and collectively, we could speak about this for hours, as we have done over the last couple of days since we've had the judgment. I think for my part, and I don't know if you all agree, there's a couple of headlines in terms of features of this judgment that comes out. Ambiguity is one, the need for guidance is the other, the potential to be involved in some kind of criminal conviction if you're commissioning or involved in commissioning some kind of services. And as I think as Peter put it, and Faye, when you dealt with that question, whether the statute is out of date. And I wonder how the Court of Appeal is going to consider the appeal and whether they'll entertain the arguments in relation to incompatibility. But that perhaps is another seminar on another date in the not too distant future, it sounds as if, because the Court of Appeal is going to make its decision pretty soon. So we've attempted to obviously answer some questions that we've had throughout. But if you have any more questions, please email seminars@kingschambers.com, and we'll try to answer them. But for now, thank you for attending. And specifically, can I ask you to thank, if we were in public, I would have asked for a round of applause for our panelists, but I can't do that. But thank you for the panelists for attending. As I said earlier, it's been a real privilege to have a stellar cast today to talk about these issues, which cross welfare and property and affairs. So thank you very much to all of you, and hopefully see you soon.